Congress enacted the Surface Mining Control and Reclamation Act through its power under the Commerce Clause. But is the environmental impact from surface mining an activity that affects interstate commerce? The Supreme Court answers this question in Hodel v. Virginia Surface Mining and Reclamation Association. After 6 years of hearings, Congress determined that the impacts of surface mining adversely impacted human and environmental health and imposed a large social cost on the public. Congress found that erosion, floods, and other hazards created by surface mining adversely affected commerce and the public's welfare. Considering this data, Congress enacted the Surface Mining Control and Reclamation Act in 1977. The act was meant to be implemented in 2 phases, an interim phase and a permanent phase. The interim phase would be enforced before states were required to adopt their own programs to implement the act in 1980. The Virginia Surface Mining and Reclamation Association, its members, and Virginia landowners sued Secretary of the Interior Donald Hodel, claiming that the act was unconstitutional under the Commerce Clause and the 5th and 10th Amendments of the Constitution. The state of Virginia and the city of Wise, Virginia, intervened. Because the act wouldn't become effective until 1980, the suing parties sought to enjoin the enforcement of the interim phase. The district court found that sections of the act were unconstitutional and enjoined the secretary from enforcing key provisions of the act. The district court held that the interim requirements took away the state's freedoms to create regulations and that various provisions of the act effectively took private property without just compensation. Hodel appealed to the Supreme Court.